The Institute for Legal Reform ranks South Carolina's lawsuit climate 37th in the nation. The SC Chamber of Commerce has identified bringing fairness to an unfair tort system as a top priority in their 2024 competitiveness agenda. But the solution appears to be simple and straightforward. Let's welcome Major General Tom Mulliken, President and General Counsel of the SC Coalition for Lawsuit Reform. Tom, we're very happy to have you here with us today.
Thank you, Taylor.
Can you talk about some of the factors contributing to South Carolina's rank as 37th for the lawsuit climate?
We have a system that is broken. It's a system of civil justice, and frankly, nothing could be more important to civil society than a civil justice that weighs equally in the balance. Mm-hmm. And we have a system now that really penalizes South Carolinians who have either money or insurance. Mm-hmm. The South Carolina Supreme Court in 2017 asked the General Assembly to cure this defect in our system, and it's something that since 2017, South Carolinians have come together and asked the General Assembly to please take a look at it. And in fact, today, on the floor of the Senate, they're debating this measure.
Okay. So what is causing the harm? What is the main issue here that we're seeing?
The main issue is we have common law and statutory law that have come together that have really prevented juries and judges from hearing and allocating fault to those responsible parties. We have parties that are settling out of court, allowing plaintiffs to bring an action in court against only those parties who have resources. Mm-hmm. So in other words, the primary case that the Supreme Court issued its opinion on, the party that was responsible for the wreck, who paid the fine for causing the wreck, settled out of court for a modest amount of insurance limits, and the ultimate action was brought against the trucking company who had very little or nothing to do with the wreck itself, but was the only party at the table when the allocation was determined by the court.
So they are pretty much found at fault for all of these damages, regardless of their percentage of fault, right?
Yes.
Okay, so what is the solution?
The solution is the South Carolina Justice Act,
which
would allow the trier of facts to hear from all the parties mm-hmm. that are responsible. Now, because of the common law principle of plaintiff choice, which allows a plaintiff to determine who they want to sue, and the statutory law that requires that 100% of liability be found against the defendants, and the Supreme Court finding that you can't implead, you cannot bring others in. We have a system now where somebody could be conceivably, and is now often 1 or 2% responsible for the action, being held 100% liable for the damages. It's the exact opposite. In the early 90s, when I helped on this issue, we had contributory negligence, which was the exact inverse, where a plaintiff that was 1 or 2% responsible could not recover any damages. Mm-hmm. Now you have plaintiffs that can recover 100% from a South Carolinian who may be only 1 or 2% responsible. That's the balance we're trying to find.
Okay, so I find it interesting that South Carolina overall is a very conservative state.
Yes.
Why we have this law put in place and why it's taken this long to have a bill passed, or trying to get a bill passed to fix this issue.
Yeah, first let me say that our actions in no way condemn trial lawyers who are out every day fighting for injured South Carolinians. But it's not a very well kept secret that we have trial lawyers in our legislature. Mm-hmm. This is the first year since 2017 that the Senate Judiciary Committee has even appointed a subcommittee for a hearing. And so we have to be careful that we don't have legislators who perhaps have their own pecuniary interest at play, mm-hmm. Stopping what is in the best interest of the state, and interests that reflect the values of South Carolinians. South Carolinians, I've met with thousands of people across South Carolina. They don't want to keep an injured South Carolinian from recovering damages, but they don't want South Carolinians who are 1 or 2% responsible, if that, being held 100% liable for those damages. We simply need a system that has blind justice and is fair to all parties, and that's what we're trying to do.
Mm-hmm. So obviously there will be great impact on these potential, small businesses that would feel this the most, the impact of this. What do you think is the potential impacts that this bill, if passed, would have on the economic growth, job creation, and the overall competitiveness of South Carolina.
We're aware that we have lost corporations looking at South Carolina because of our system of civil justice. Clever advocates have tried to make this into an insurance issue. The insurance is the manifestation of the broken system. If you can imagine taking these situations where a party was 1 or 2% responsible and being found liable for a $90 million judgment, the actuaries and insurance companies don't know how to assign risk and cost for insurance. So insurance companies are fleeing the state, and those that are left, insurance rates are rising because we simply don't know what that risk is they're insuring.
Yeah.
What we'll find is a healthier environment for insurance companies, a healthier environment for those companies looking to locate here, and frankly, with pure comparative negligence, a situation where our injured plaintiffs would also benefit by bringing all the parties to the table. Now it's simply a matter of judgment stacking. Attorneys are able to settle out of court with individuals that have insurance, wait and bring the deep pocket to the table, when the best for them may be bringing everybody to the table at the same time.
Absolutely. For more information, sclawsuitreform.org and of course schamber.net. Tom, thank you so much for joining us today.
Thank you, Taylor.
We're back in 2 minutes.